What about dead rent, fellows? Remain a tax.
In India Cements, they included the word
No,
royalty.
dead rent is, sorry, go.
In India Cements, the problem arose because they included the word royalty in the definition of that particular impost or cess.
Fellows, with respect, fellows, I'll read those two paragraphs. Mr. Ganguly will read that also. Straight away. Para 34, India Cements is not allow me to answer. No, straight away. Yes. But may I say, India Cement, independently on first principle, holds royalty to be tax. Directly and clearly, not because it's included here or there. Then it says, cess is another kind of tax.
Yes.
Therefore, tax on tax is bad. But royalty is a tax is independently on first principles held by India Cement.
Stems from the fact that the word royalty was included in the definition.
No, but
Yes.
respect, no. I'll show that.
Of the State Act.
But it will make no difference. But obviously, a tax of any kind will have to have some statutory basis.
Yes.
Under Article 265, your lordship cannot have. So it has to have some backing. But the basis is therefore statutory in the not the strict sense, but let me say sovereign levy, exaction and enforceability. Your lordships cannot have a tax. Well, suppose I contractually demand something, it won't be a tax. So that much will be there always. But India Cements is directly holding it to be a tax. It is holding it because it is an exaction. Of course, they had a separate question. The first para puts it that is this cess on royalty valid? So cess on royalty makes it worse. It's already a tax. On that you put another tax. So that's the issue. But for us to come back to this, dead rent is a good example because dead rent is a for sure a tax. Tax, dead rent is a for sure a tax because it's an idling charge. You do nothing, you still pay it. It's a compulsory, it's exactable, it's enforceable, no option.
Dead rent is a tax. Dead rent is also very intrinsically related to royalty. That's why the proviso to section 9A1 says that when the holder of a mining lease becomes liable to pay royalty, he shall pay either royalty or dead rent, whichever is higher. So it is really in the nature of it's for the exercise and therefore non-exercise of the mining right.
Let me answer that.
It's relatable, it's relatable to the exercise of a mining right. If dead rent, your concept
No, with respect,
the tax may not be correct.
It is with respect. Right. It's conceptually the very same point I'm making. It has to be related to royalty because if you mine and extract, you will pay royalty. Now, if you don't mine and extract, you are squatting, which is why you pay dead rent. It's an idling charge. I started by saying that.
Tax.
Well,
it's a charge which you pay to the state for not having exercised your right to extract, and therefore the state is losing revenue.
It's not optional.
And therefore, you have to pay.
It is. So, what is the? That's why 36020 impost. What characteristic of a compulsory levy does it not have? It's compulsory. It's 9A. It can be enforced by 25. The man can't, and the rate can be changed by amendment to the third schedule. Your lordships can't change the rate without amending the third schedule. It is completely a tax, fellows. And the whole idea of putting 36628 was to catch those minor creases which said that no, it's not a tax in a full form called so. Fellows, your lordships can't change the rate except a third schedule amendment. And 25, same recovery procedure. So,
9B5, which is the District Mineral Foundation, and 9C4, which is the National Mineral Exploration Trust. This is all paid as a component of royalty.
No, with respect, it is alternative.
Instead of passing this 9B and 9C, they could have just enhanced the rates of royalty. They put an additional provision.
Let me explain.
It doesn't cease to have that connect with royalty.
9A, 9B. Are all taxes.
And
9C can be a fee.
Assuming royalty is a tax.
Yes.
Where is the bar on the states imposing a tax on mineral right? Because it's still in the nature.
That's my fourth proposition. That's coming. That's my fourth proposition.
There's no bar on the.
I am conceding. Let me shock your lordship by saying my fourth proposition. Say I concede that, but you are not levying a tax on mineral rights. For a minute, for the purpose of argument, let me concede that you have a right to. I'm not accepting anything. Concede the fact that you have a right to levy tax on mineral rights. Allow me, that's my fourth proposition coming up. But let me finish my third, brothers. My third proposition therefore rests with 9A and 9B. Kindly read them carefully.
So what is the proposition in section 9?
This is my proposition number 3, Malus, at my first page, 320.
How do you formulate it?
Yeah. 9, 9A, 9B
Yes.
are taxes because they are compulsory imposts by a public authority enforceable by coercive measures, bracket e.g. land revenue, etc., and are changeable only by statutory amendment. There is nothing else a tax has, brothers. No tax will have anything except this. No tax. Otherwise, the whole concept of tax will change. And if 7 judges in India have held so, why should your lordship depart unless there's something fundamentally wrong? This was accepted by India 7 in so many cases. It's just that Kesharam has created this new thing. 9C is, however, a fee because there is a quid pro quo of exploration. I myself said so in my note. 9C has an element of quid pro quo and is a fee. It's an exploration issue. Third point was, apropos the Honorable Chief Justice's query. Two more sentences on this only. 9A, which is dead rent, has to be alternative because when you don't mine the land and extract minerals and squat or waste time or sit there idling, then dead rent comes in. So the very concept is in the alternative. That's the concept of it. The whole idea is that you must mine.
All right, there's a third point now.
And the last is that some of these calculations in one or two of these cases is done by a percentage of the royalty. That's a calculation. That has nothing to do with changing the character. It says that you will pay at X percent of the royalty. This completes my third point, but the most important part of the third point is the look back nature, non-vanilla nature of entry 50. I've done proposition 3 minutes. Proposition 4 is what my Lord the Chief Justice just now asked me. No, I'm sorry, Malas, I have not finished. I have to read very quickly this previous point. Please turn to A11, Malas, page 310. I was conceptualizing it. I have not. This will be very quick. I'll just read it very quickly. On the previous point, Malas, that is on this 50 look back and 97. Come to Malas para A11. Extremely important. Such important judgments are completely, Malas, put to the side by Kesharam. That's the only reason, Malas, your lordships have to exert. Please turn to Malas, page 310. Does my lord have it? All my lords have got it? Yeah. Now I'll read the bold face only, Malas. I'm skipping. This is Mahalakshmi. Once the parliament has occupied the field in connection with regulation of mines and minerals development, and when the parliament declares it is expedient in the public interest to do so, entry 23 of the state list regarding regulation of mines and minerals would be of no avail to the state legislature, as entry 23 is subject to list 1. Nor will entry 50 be of any assistance in this case. Kindly go further, the bold portion. Once these entries are out of the picture, it is entry 54 in the union list which will operate, and the imposition of tax on minerals extracted would be squarely covered by 54. Now come to the next page. Section 9 being part and parcel thereof cannot be out of the sweep of 54. However, even assuming that there should be a specific taxing entry regarding taxing of royalty on mineral rights which can sustain such legislation under the said entry, being a topic of legislative power, we find that there is no such specific entry in union list nor in state list or concurrent list which can be of any assistance in this connection. Entry 50 in the state list is out of the picture. That's non-vanilla entry. Then, Malas, in the alternative imposition of such hybrid tax on mines, on capital, on labor, would be covered by the residuary entry 97 of the union list, which empowers the parliament to enact laws on topics not covered. Now go further, Malas. It is not a flash in the pan. It is not, Malas, one solo which I want to make a summer out of. Come to, Malas, the next judgment, Saurashtra. Now, that's a read. No, I'm going to cite it. Now, Malas, the next para is Saurashtra. This is not that Saurashtra, Malas. This is the Supreme Court Saurashtra. Yes. The other one was the Gujarat High Court. The bold face. Section 9 and 9.3 thereof, by holding that by entry 54 of list 1 it was within the legislative competence to make the law in question, neither 23 of list 2 nor 50 of list 2 would be attracted. It is no doubt true that in the aforesaid case, that is Mahalakshmi, aforesaid case, The court also held that 97 will confer legislative competence, but not because Parliament has no competence under entry 54. They went further. 54 is enough. 97 is an additional prop. Now let us come to A15. Kannadasan, I am not citing, Mr. Salve was dismissive of it, I am not citing for that purpose at all. I am citing that when your lordships had so much collections and you had to help the states to not get refund, you passed Kannadasan, you passed the Validation Act, and it came for Kannadasan. Look at these highlighted paragraphs. Shri Sanghi argued that the denudation is not absolute, but only to the extent provided in the MMDR. Section 9, Learned Counsel submitted one of the facets of the extent of denudation. This partly will deal with the extent argument also. This contention assumes that notwithstanding the declaration in 2, the states still retain the power to levy taxes upon minerals over and above those prescribed by the MMDR, and that a fresh declaration is called for whenever such subsisting power is sought to be further encroached upon. That was the original argument. Each time you must have a fresh declaration. Then 313, page 313. The denudation is not partial, it is total. They cannot levy any tax or cess on minerals so long as the declaration in section, there is a misprint there, 2 stands, 2 is missing. Once the denudation is total, there is no occasion or necessity for any further declaration or for that matter for repeated declaration or denudation. Now, Malas, let me make the submission after I finish. Come to para 17. Even assuming without conceding that the declaration in 2 does not ipso facto oust the state's legislative competence, I am arguing in the alternative, expressly contemplates the levy of taxes thereunder as evident from section 25, and the fact that it levies a royalty, which is a special kind of tax under 9 and a dead rent under 9A, denudes the states. Conclusion in 18 is very important. Conclusion. Thus, even assuming entry 50 is to be read restrictively so as to require an inquiry as to whether any specific provision imposes a tax,